Mr. Holt, that space is no longer yours. Effective immediately, Spot 14 has been redesignated as a visitor loading zone, and your continued use of it constitutes unauthorized occupancy. You will receive a formal notice by end of week. That was Diane Marsh, president of the Kessler Ridge Homeowners Association, standing beside my truck on a Tuesday morning in July with a clipboard pressed to her chest and a look on her face, like she had just handed down a ruling from a higher court. She had been president for 4 years. She wore a cream-colored blazer over a tank top, which was the kind of outfit that made sense in a board meeting and made no sense whatsoever in a parking lot at 7 in the morning. She had a laminated ID badge on a lanyard that said her name and her title, and she held her clipboard at an angle that suggested she had signed things on it recently and expected to sign more. Behind her, across the back lot, her husband Greg's construction company had 2 trucks parked inside the covered garage, the HOA board used for overflow storage. A garage that sat on a parcel in the northeast corner of the property. A parcel Diane apparently assumed the association had owned outright since the day the community was built. What she did not know was that I had spent 31 years managing commercial properties, and that reading a deed was not something I needed help with. What she did not know was that the deed to my unit contained 4 lines of recorded language. An easement appurtenant conveying Spot 14 as an exclusive use parking space, and that no HOA resolution in any state in this country can revoke an appurtenant easement. What she did not know, and what I did not know yet, but would find out within the month, was that the garage sitting behind her, the one where she and every board member parked their vehicles every Tuesday night before meetings, was built on a parcel that her husband's company had never properly transferred to the HOA. The taxes on that parcel had not been paid in 22 months. It was sitting on the county's delinquency list, and I had enough money in a savings account to buy it outright. I want you to think about what you would have done standing in that parking lot. Because I did not argue with Diane Marsh that morning. I said, "I'll look into it," and I went back inside and started a folder. My name is Ray Holt. I am 58 years old. I grew up in Mecklenburg County, which is Charlotte Metro, and I learned about deeds and plats and easements the same way most people in that county learn things, from watching someone else get burned and paying close attention. My father managed rental properties for a local real estate company for 27 years, and I used to sit in the office with him on Saturdays when I was 12 or 13 and listen to him read instruments aloud, the way some kids hear their parents read scripture. I went to work in facilities management straight out of college and stayed in commercial property for 3 decades, eventually running a mid-size portfolio out of Raleigh, covering office parks, light industrial buildings, and 2 strip retail centers. I know how to walk a boundary. I know how to read a plat map. I know what an appurtenant easement is, and I know the difference between an appurtenant easement and a license. An appurtenant easement is a right that runs with the land and survives every subsequent conveyance. A license is a revocable permission. They are not the same instrument. They do not behave the same way. An HOA can revoke a license because a license exists at the board's discretion. An HOA cannot revoke an appurtenant easement because the easement is attached to the deed, recorded at the county, and older than the board's authority over it. This is not complicated law. It is first-year property law, and any attorney who specializes in real estate transactions knows it from memory. None of that mattered to Diane, because Diane had never read my deed. My wife Linda bought the unit at Kessler Ridge in November of 2009. She was 39 at the time, and she had been researching small investment properties for 2 years, which for Linda meant reading everything twice and asking questions in writing and keeping copies of the answers. She liked the unit because it backed up to a mature tree line, and because the HOA assessments were reasonable, and the reserve fund was adequately capitalized, which she had confirmed by requesting 3 years of audited financials before she made an offer. Linda was thorough in a way that was not anxious or compulsive, but simply correct. She did her homework, she filed her documents, and she did not assume that other people had done their jobs until she had verified it herself. The deed to the unit, recorded at the Wake County Register of Deeds in October of 2009, included in its easements and restrictions section a paragraph granting the owner of the unit the exclusive use of parking space number 14 in the surface lot adjacent to the north building. The paragraph used the word appurtenant. Linda underlined it. I found the underlining when I reread the deed the week she died, in October of 2018, 14 months after the doctors identified what was wrong and not enough months after that to do anything about it. I moved into the unit in the spring of 2019. Our daughter Mara was finishing her junior year of high school in the district, and I did not want to move her. And I will be honest and say that I also did not want to leave a place Linda had chosen carefully. The deed transferred to me as part of the estate, re-recorded at the county with my name, the same instrument number, the same 4 lines in the easement section. Spot 14 came with it. I knew that from day one. I had read the deed. Mara was 17 that summer, working a part-time job at a garden center about 2 miles down the road, and doing most of her driving in my truck because her car was in the shop for most of June and July. The distance from our unit's front door to spot 14 was about 45 seconds on foot, door handle to door handle. The distance from our unit's front door to the overflow lot Diane wanted to reassign me to was 1/4 mile, around the back of the east building, partially unlit, and crossed by a traffic lane used by the landscaping contractor's trucks on their early Monday runs. This was not an abstract inconvenience. This was my 17-year-old daughter in the dark at 6 in the morning. I explained this to Diane in the letter I sent in response to her formal notice, which arrived on a Thursday and cited Section 8.4 of the HOA Declaration of Covenants as the authority for the redesignation. Section 8.4 governed aesthetic modifications to common areas. It addressed landscaping decisions, exterior color palettes, and signage standards. It said nothing about parking spaces. It said nothing about extinguishing a recorded easement, which is not a thing any HOA board can accomplish through an internal resolution, regardless of which section they cite. I wrote all of that in the letter, clearly and without editorial tone. I cited the recorded deed, the easement language, and the instrument number. I cited the general principle that an appurtenant easement survives subsequent conveyances and cannot be administratively revoked by a third party, whose authority derives from a declaration that was itself recorded after the easement. I was polite. I was specific. I sent it certified mail, return receipt requested. I kept a copy and stapled the certified mail receipt to it. That letter and its attachments were the first entry in the folder. I wrote on the cover in black marker the date, a 1-line summary of the incident, and the number 1. Diane did not respond to the letter. Her management company did not respond to the letter. What I received instead, 8 weeks later in the 3rd week of September, was a violation notice in an envelope with the HOA management company's return address. It stated that my vehicle had been observed occupying the visitor loading zone in violation of community parking regulations and that a fine of $75 had been assessed against my account. It directed me to remit payment within 30 days or face additional penalties at the board's discretion. It was signed by Diane in her capacity as president. I photographed the notice before I touched it. I photographed both sides, including the date stamp on the envelope. I set the notice on the kitchen table. I did not pay it. I wrote a short response acknowledging receipt, noting the recorded easement instrument number, and stating that no fine associated with the lawful use of that space would be paid. and that any further fines would be added to a documented record of the dispute. I sent that response certified mail as well. Then I pulled the full HOA declaration and read it cover to cover that weekend, all 47 pages. Section 8.4 did exactly what I expected. I also read the exhibits attached to the declaration. Exhibit C was a site map of the Kessler Ridge property showing the parcels under HOA governance. The garage in the northeast corner was on the map, but the parcel boundary lines on that exhibit were hand-drawn on what looked like a photocopy of an older plat. And the lines around the northeast corner were slightly misaligned with the lot lines I had seen on the county assessor's map when I looked up my own parcel number years earlier. It was a small thing and might have meant nothing. I wrote a note on an index card and put it in the back of the folder. The fine notice went in the front. I wrote the number 2. Phil Tanner had lived 3 units down the hall from me since before I moved in. He was 64, recently retired from 22 years doing title work for a mid-size real estate law firm in Raleigh. And he walked the perimeter of the Kessler Ridge property every morning for 30 minutes because his orthopedist had told him that walking on flat terrain was the only exercise his left knee would tolerate without complaining. He had known Linda casually the few times she had stayed in the unit, and he had been kind to me in the months after I moved in without making a production of it, which is the kind of kindness that actually registers. He knocked on my door on a Saturday in November, said he had seen the loading zone paint job on the surface lot, and asked if I had sorted out the parking situation. I told him what was in the deed. He asked to see it. I got the folder and showed him the easement language and the recorded instrument number. Phil sat at my kitchen table with the deed in his hands and read that section twice without speaking. Then he set it down and said, "That's appurtenant. They literally cannot do that." I told him I was aware. He asked if I had looked at the garage parcel in detail. I told him about the index card in the back of the folder and the misaligned lot lines on the exhibit map. He leaned back in his chair and looked at the ceiling for a moment. He told me he had a contact at the county register's office and that he would ask her to pull the ownership and tax records on the northeast corner parcel as a casual favor. He said it might be nothing. I told him anything he found would be useful. I added his name to the folder with the date. Mara came through the kitchen on her way to work, saw us sitting over the folder, and asked if we were making progress. I told her we were gathering information. She grabbed her keys and said, "Good," and went out the door. The boot appeared on a Wednesday morning in January. I came downstairs at 7:15 and walked out to find a bright yellow wheel clamp locked to the front left tire of my truck, with a laminated notice taped to the driver's window in a clear plastic sleeve. The notice stated that my vehicle had been immobilized pursuant to HOA parking regulations for repeat violation, that I was required to contact the management office during business hours to arrange removal, and that the removal fee was $120. The temperature was 31 degrees. Mara was behind me. She had a shift at 8. I stood there for a moment and looked at the clamp. Then I took out my phone and started photographing. I photographed the clamp from 4 angles. I photographed the notice inside the sleeve, both faces. I photographed the position of the truck in the space, the faded number 14 still legible under the loading zone striping, and the absence of any other vehicle anywhere near the loading zone at that hour. Then I called Phil. He came down in his coat and boots inside 5 minutes and took his own photographs on his phone. I called a cab for Mara and waited with her until it arrived. She did not complain. She did not. She just looked at the truck and then looked at me and said she would make it work. After she left, I called the management company's service line, reached their overnight answering service, and left a message that identified myself by name, unit, and parcel number, cited the recorded easement instrument, stated clearly that the clamp had been applied to a vehicle in a deeded parking space in violation of a recorded property right, and noted that I was documenting the incident for purposes of a potential legal proceeding. The clamp was removed by 2 that afternoon. No one called me back. I added the photographs, the notice, my message transcript, and a note from Phil confirming his independent documentation to the folder. That was 3. The HOA's attorney, a man named Corbin, who worked for a small firm in Cary, sent a letter in March. 2 pages, firm letterhead, professionally formatted. It argued that the loading zone redesignation was a valid exercise of the association's authority under the Declaration of Covenants, that my vehicle's continued occupation of the designated visitor loading zone constituted a trespass against common area property, and that further non-compliance could result in legal action, including injunctive relief and attorney's fees. He cited 3 cases in support of the board's position. I printed the letter and read it twice. Then I looked up all 3 cited cases. The first was an appellate decision from Georgia involving a condominium board's authority to reassign amenity licenses. The second was a North Carolina trial court opinion about landscaping access rights. The third was an HOA fee dispute from Virginia. None of the 3 cases involved an appurtenant parking easement. All 3 involved license-based parking assignments, which are a completely different instrument. A license does not run with the land. A license can be modified or revoked by agreement. An appurtenant easement recorded in the deed is not a license and cannot be treated as one. I wrote a 2-paragraph response to Corbin's letter. In the first paragraph, I noted the legal distinction between an appurtenant easement and a license assignment and stated that the 3 cited cases did not apply to the present situation. In the second paragraph, I provided the recorded deed instrument number for the 4th time in our correspondence and invited him to pull the instrument from the county register and review the language before proceeding. I was still polite. I sent it certified mail. I kept the copy. I put Corbin's letter and my response in the folder. 4. I also called Phil that same evening and asked what he had found on the garage parcel. He told me his contact at the county had pulled the tax records. The parcel was registered to Kessler Property Holdings, LLC. It was not registered to the Kessler Ridge Homeowners Association. Tax payments had lapsed 22 months prior. The parcel was actively listed on the county's delinquent tax roll and was scheduled for public auction if the arrears were not resolved within 90 days. Phil read me the outstanding balance, $4,212. I sat with that number for a moment. I asked Phil if he knew who was registered as the agent for Kessler Property Holdings, LLC. He said he would check. He called back 20 minutes later. The registered agent was Greg Marsh, Diane's husband, the man whose trucks were parked in that garage every Tuesday night. I looked at the ceiling for a good while. I thought about what Diane had said that Tuesday morning in July, the part about the loading zone being part of a broader beautification plan for the community. I thought about what Greg's company did for a living. And I thought about the north side parcel adjacent to the property that had been cleared of scrub trees the previous spring. A development company does not clear land without a reason. Diane's loading zone plan was not about aesthetics. It was about square footage. The visitor loading zone was sitting at the entry approach to the north building, exactly where a new building addition would need ingress access. Diane had been laying groundwork for Greg. She had just been doing it on a parking space that was not hers to touch. I looked at the folder. Then I called Phil back and asked him to walk me through the county's tax auction process in detail, because I had done commercial property work for 30 years and I had never personally purchased at a delinquent tax sale, and I wanted to understand the timeline and the redemption rights. Phil walked me through it over the next 45 minutes. I took notes on 3 pages. Deputy Carla Webb came to my door on a Thursday in May. She was in a tan sheriff's uniform, middle 40s, calm and direct. And she explained that she had received a complaint from a Kessler Ridge resident, alleging that a vehicle was being repeatedly parked in violation of HOA parking rules, that she was obligated to investigate filed complaints regardless of their merits, and that she was there to hear my side. I invited her in and offered her coffee, which she declined. I set the folder on the table and opened it. I showed her the deed, with the easement language and the instrument number. I showed her the sequence of notices, fines, the boot documentation, and the attorney correspondence. She looked through the contents without touching most of it. She was careful. She asked how long the dispute had been running. I told her since July of the prior year. She looked at the exhibit from Corbin's letter and at my response. She said the recorded easement was clear and that she could not take any enforcement action against a person exercising rights under a recorded property instrument. Then she looked at me and said, "You've been tracking this carefully." I told her I had been in property management for 3 decades and that careful records were a professional reflex. She said, "Keep going. If this escalates the way these situations sometimes do, a clean documented record going back to the first incident is what a judge wants to see." She said in her experience, 6 documented incidents with dates and written evidence was where it started to matter. I thanked her and walked her to the door. I added her name, badge number, and the date to the folder. That was 5. The 6th came in August, when a code officer arrived on a complaint that my truck constituted a commercial storage vehicle in a residential parking area, based on the presence of a pair of work boots and a folded tarp in the bed. His name was Dennis. He was a careful, slightly apologetic man who walked a full circuit around the truck, wrote several notes on his clipboard, and told me that what he observed did not meet any definition of commercial storage under the county's residential zoning code, and that he was closing the complaint as unfounded. He said, not looking up from his clipboard, that it was the 3rd time in a year he had been called to this address, and that, in his experience, repeat unfounded complaints to code enforcement tended to tell their own story. I asked if he would provide a written inspection report. He said he would, and he did, within 5 business days. Clean, unfounded. His name, his inspector number, the date, and 3 paragraphs of factual observation with no citation against the vehicle or its owner. I added it to the folder. 6. That evening, I called Phil and told him I was ready to move on the tax parcel. He confirmed the auction date. The 2nd Friday of September, County Tax Office Annex, 9 in the morning. He offered to come. I told him that would be useful, and I was glad for the company. The auction room was beige-walled with fluorescent tubes overhead and folding chairs arranged in 4 rows. There were 11 parcels on the morning list and roughly 30 people in the chairs, some of them professional buyers who showed up with bid sheets already filled in, and some of them individuals who had clearly never attended a tax auction before and were reading the posted rules on the wall more carefully than they had expected to need to. The garage parcel came up 4th on the list. The county's opening bid was the full outstanding tax balance plus penalties and administrative fees, which came to $4,212, same figure Phil's contact had given me in May. I submitted my certified check and my bid sheet. No one else bid. There was a brief pause while the clerk confirmed the instrument against the county's records. And then a stamp came down on the bid sheet, and the clerk's assistant handed me a receipt and told me the deed transfer would be recorded within 60 days, pending any right of redemption period. I folded the receipt and put it in my jacket pocket. Phil sat beside me in the folding chair and did not say anything until we were standing in the parking lot in the September sun. Then he said, "You just bought their garage." I told him I was aware. He said it again, slightly differently, the way people do when a fact is still settling. He said, "Ray, You bought the garage they have been parking in for 12 years. I said yes. He laughed. It was a good, genuine sound, and it carried across the parking lot, and the woman loading files into her car 2 rows over looked up and then went back to her files. I drove home and found Mara in the kitchen making a sandwich. I told her what had happened. She turned around and looked at me with the knife still in her hand. She said, "Does Diane know?" I told her she would find out. Mara put the knife down and said very quietly, "Good." I sat at the kitchen table with both folders in front of me and the receipt sitting between them. I thought about Linda and the way she had underlined the word "appurtenant" 14 years ago in the quiet of a title company's office, making sure she had what she was paying for. In October, Diane called a special community meeting. The notice went out by email and posted on the board near the mailboxes. It announced a vote on what Diane termed a permanent beautification infrastructure package, which included concrete wheel stops for the visitor loading zone and a plan to expand the garage for additional board and community storage. The meeting was scheduled for a Thursday evening at 7 in the community room on the ground floor of the main building. I confirmed I would attend. I did not RSVP in any way that would signal anything. I simply wrote the date in my calendar and spent the intervening weeks getting the deed transfer from the tax auction formally recorded at the county register, which happened on a Tuesday, and making clean copies of both instruments. Phil came over the Sunday before the meeting and looked over what I planned to bring. He said, 2 pages. That's all you need. I agreed with him. Sandra Lee, who had been on the HOA board for 2 years and who had abstained on the original loading zone vote without giving a public explanation, had left a brief message for me in mid-October, saying only that she thought the board should have consulted legal counsel before the loading zone change, and that she hoped things would be resolved properly. I saved the message and added the date to the folder. I did not call her back. The community room held about 50 people at capacity. There were 43 residents in the chairs by the time Diane called the meeting to order. Phil sat to my left in the back row. Corbin, the attorney, sat at the table beside Diane, with Greg on her other side. Greg had the build of a man who had spent years in physical work before moving into management, and he sat with his arms crossed and his attention directed mostly at his phone during the opening remarks. Diane thanked everyone for coming, explained that the beautification package had been in planning for several months and would significantly improve the community's common area aesthetics, and said the concrete installation was already contracted and awaiting board authorization before the crew could schedule. She read the motion aloud. It named Spot 14 explicitly. I waited until she finished reading. Then I raised my hand. Diane looked at me the way she had looked at me for 2 years, with the compressed patience of someone who has decided the outcome in advance and does not appreciate the interruption. She said, "Mr. Holt, this is a board vote, not a comment period." I stood up anyway. I said, "Before this board votes to install permanent concrete structures in Spot 14, I need the board and your attorney to look at 2 documents." I walked to the front of the room. I set the first document on the table in front of Corbin without any announcement. It was a clean copy of the recorded deed to my unit, opened to the easement section, with the relevant paragraph legible from across the table. Then I set the second document beside it. This one was the recorded deed transfer from the county tax auction. My name, the parcel number, the instrument date, and the county clerk's stamp. The parcel containing the garage. Corbin picked up the first document. He read it without looking up. The room was quiet. He set it down and picked up the second document. He read the parcel number. He read the instrument date. He set it down carefully, the way you set something down when you have just understood that it is heavier than you thought. Diane said, "What is that?" Corbin said, "Give me a minute." He read the second document through a second time. He turned to Diane. He said, "The parking easement. It's recorded as appurtenant. We cannot install structures in that space. We should have caught this before we sent the first notice." Diane's face went through several things at once. She said, "You told me in March that we had legal authority." Corbin said, "In March, I didn't have the recorded instrument. I was given a description of the situation that characterized the space as an amenity license. This is different." He turned back to the second document. Quietly, almost to himself, he said, "This parcel, this has been in arrears?" I said, 22 months. I purchased it at the Wake County tax auction on the 14th of September. The deed transfer was recorded 11 days ago. The instrument number is on the document. Greg Marsh stood up from his chair. His voice came up with him. He said, "That parcel is HOA property. That has always been HOA property." I said, "It was registered to Kessler Property Holdings, LLC, for the full duration of its existence on the county rolls. Your company. You did not pay the taxes for nearly 2 years, and it went delinquent. I bought it at the county's public auction. That is a recorded instrument in front of your attorney right now." Greg said, "There must be a filing error. The transfer was supposed to go through in 2011. I said, "It did not. The deed is what was filed, and what was filed shows the parcel staying in your LLC. You can dispute the title in court if you believe there is an error, but as of today, that parcel is mine." Corbin was looking at the document very carefully. He said, without looking at Greg, "If the transfer deed from 2011 had a legal description error, the conveyance was ineffective." He looked up. He said, "We need to stop the meeting." Greg said something I could not fully make out. Sandra Lee, 3 rows ahead of me, turned in her chair and looked at Diane, and then looked at me, and then said, to no one in particular, but at a volume the whole room could hear, "I told you to verify the title in 2021 before we voted on anything. I abstained because I said we needed to check the instruments first." The room absorbed that. A man 2 rows to my right leaned over to his wife and said something in a low voice. Diane was still standing. She looked at Corbin. Corbin said, "I'm requesting an emergency adjournment to review the title situation with the full board in private." Diane seconded her own adjournment motion. It passed with 4 hands raised and no votes against, because most of the board members had already understood that something had gone wrong and were no longer interested in registering a public position. I collected my 2 documents from the table, nodded to Phil, and walked back to the last row and out the door. Mara was in the lobby. She had driven herself over after her shift and parked in spot 14. She looked up from her phone and asked how it went. I told her the vote was adjourned. She said, "Did she know?" I told her she did now. The formal review took 6 weeks. Corbin's firm ran a full title examination on the HOA's governing documents and all associated parcels. The 2011 deed from Kessler Property Holdings to the Kessler Ridge HOA contained a legal description error that misidentified the northeast corner parcel by a single digit in the section and township reference, which made the conveyance legally ineffective under North Carolina recording law. The parcel had stayed, technically and legally, in Greg's LLC the entire time. The HOA had built the garage on it. 14 reserved spaces, 12 years of use. The county assessor valued the garage structure at $280,000. Corbin advised the board that under an unjust enrichment theory, they faced potential liability in the range of $340,000. Greg's development company had a pending expansion permit application for the north side of the property, the same north side parcel that had been cleared of scrub the previous spring. That application was quietly withdrawn within 2 weeks of the meeting, before the county's planning office had formally acted on it. I found out later from Sandra that the withdrawal came on Greg's own initiative, and that he had not consulted Diane before filing it. Diane submitted her resignation as HOA president, citing personal reasons, effective the 1st of November. She did not give a public statement. She was not at the following month's community meeting. Sandra Lee was elected interim president by the remaining board members at that same meeting, 4 votes to 1 with 1 abstention, and one of the first things she did was post a full copy of the community's governing documents in the lobby and invite any resident with a question about their deed to bring it by on Sunday afternoons. Sandra told me that 9 residents came by in the first month with easement questions they had never thought to ask before. 3 of them found language in their deeds they had not known was there. The HOA's new legal counsel, a different firm, reached out to me through Phil to begin negotiations on a formal easement agreement for continued community use of the garage parcel. We settled on an annual access fee that covered my $4,212 purchase price within the first calendar year, with a 10-year term and a renewal option. My violation record with the HOA was cleared. The $75 fine and the $120 boot removal fee were both formally waived. My name was removed from the non-compliance log. Sandra Lee called me the week after the settlement was signed and said she was sorry she had not pushed harder in 2021. I told her the abstention vote had mattered more than she probably knew, because it had created a documented record that the board had not been unanimous. She was quiet for a moment and then said that she appreciated me saying that. I meant it. Mara drove the truck to work on the Saturday after the community meeting, the morning after the settlement was signed, and she did not say much about any of it. She came home that evening with dirt on her work boots and set her keys on the kitchen counter next to the folder, which I had left out for one more day. She looked at the folder for a second. She picked up her keys and turned them over in her hand. She said, "Mom would have liked this one." I told her I thought exactly the same thing. I told her Linda had underlined one word in the deed the day she signed it, and that word had done the work. Mara nodded and went to change her boots. I put the folder in the filing cabinet where it belonged, behind the deed and next to Linda's copy of the original purchase agreement from 2009, which still had her handwriting in the margin next to the easement section. The parking space was mine. It always had been. Here is what I want you to take from this. When you buy a property, you need to read the full deed instrument, not just the purchase price and the address. There is an easements and restrictions section. Read every word of it. If your parking space, your water connection, your driveway, or your outbuilding is described there as an appurtenant easement, that language was recorded at the county register before you owned the property, and it will be there after you sell it. No board resolution, no fine letter, no attorney notice changes that. Second, go to your county assessor's public records and look up the parcel number for every shared structure in your community. A garage, a gatehouse, a utility building. Compare the listed owner against the HOA. If they do not match, ask why. Pull the tax records on that parcel. If the taxes are delinquent, find out by how much and how long. I bought a garage for $4,212. Third, start the folder on the first incident, not the third. Date everything. Keep copies. Send certified mail when you write back. The folder is not a dramatic gesture. It is your case, and your case is the folder. Drop your own story in the comments if this one felt familiar. I read them. If you want to hear how this kind of fight unfolds when there is no deed in the drawer at all, subscribe, because next week I am talking about a woman who paid road maintenance fees to her HOA every year for 9 years before a county surveyor told her the road had belonged to the county since 2003. Nobody in that HOA had looked at a plat map in a decade, and the fee had been collected the whole time. That one gets interesting fast. Thank you for listening.